put him on record.
Must have told on me. He must have told on me. Davis keeps texting me. He must have told him I was here.
Everybody back.
He's texting me.
10 minutes up. 10 minutes. Okay. Our break is over. We're back in session. Okay, Mr. Steve, you want to be first and get the items that you have there, sir?
Yes, sure. First of all, I want to go over reasonably safe from flooding. That's a term that's used a lot in this ordinance. It's a term that's used a lot in the FEMA Bible, we'll call it, the Code 44, Code of Federal Regulations, that this ordinance is devised off of. So leaving reasonably safe from flooding, I don't think we can take that out of there. It does give Mr. Wellings, our current floodplain coordinator here in Doddridge County, it gives him basically use common sense. Don't let that trailer go in by the stream and don't, just put it right there on the ground basically without anchoring that thing, elevate it to the right height, doing it the right way. And if he allows it to go in the wrong way, Doddridge County's liable because he made a really bad choice. They just stuck a little single wide in there right next to the stream. It goes down, it hits a bridge, it backs up, it floods you and a couple other neighbors. That's their fault. They shouldn't have made that. That was a bad decision because in the ordinance it says they got to put it on reinforced piers, they got to elevate it, they got to anchor it, and they got to make sure it's not going to flood you, the neighbors. This ordinance that they're talking about here, it applies to the floodplain only. If you're out of the floodplain, you come down and you say, Dan, I need to get a permit, but I'm up on this hill. I'm on the floodplain. That's the end of the story. That should be it. There is a web tool out there that we have spent millions of dollars, FEMA dollars at that, which is even better. It's not our money, but we devised it for you, for all of West Virginia, to go in and determine whether you're in or out. It's close. Sometimes if it's within 50, 75 feet, the floodplain coordinator will say, hey, you need to give me an elevation certificate because you're so close to that floodplain. That way we know how high to tell you to build. But if you show that you're out, he'll teach you how to go through the LOMA process, or you can give me a call and I'll help you go through the LOMA process with your surveyor to get your LOMA, so the bank will never say you have to carry flood insurance. Banks have that right. When they loan you money, they got the right to protect your investment. That loan is like gold. That's what I always tell everybody. You get a loan from FEMA saying you're out of the floodplain and you're close, sell them a whole lot easier, stuff like that. And last little thing I want to touch on before I go over my 7. Permanent fees, as far as the state's concerned and FEMA's report is concerned, we don't have no fight in that battle. We don't have no dog in that fight. It's not going to happen. FEMA does not care how much Doddridge County charges. The state has no say-so with that. All we are is technical advisors for the county commission. And we help you all out when you have problems or issues. Your neighbor put in that trailer by the stream, you call us and we'll call Dan and we try to help you go through that. All right, I just wanted to get that off my mind there. Well, I heard that stuff being talked about earlier. I want to clarify that. As soon as I got this ordinance, I sent a copy up to 2 people at FEMA. It's our Region 3 people. And I said, give me your take on it. I had to review it. I gave her my take on it. But this is what comes from her. And she's been at this. She's a very intelligent lady, and she knows what she's talking about. So
what is her name, Kevin?
It's Mari Radford.
Mari?
Mari Radford.
Do you know how to spell Mari?
Yeah, M-A-R-I. R-A-D-F-O-R-D.
Thank you.
She is our FEMA Region 3 representative.
Thank you.
Last name? What's the last name?
Radford.
Radford, R-A-D-F-O-R-D.
Thank you.
First of all, she said she didn't like the last sentence under authority and purpose. That's on the very first page here. This ordinance is an establishment regulation of a way as the same. It just doesn't make sense to her. And it really didn't make a lot of sense to me. If you've got the ordinance, under the very first page, under authority and purpose, on the very last sentence, it states, this ordinance is an establishment and regulation of a way as the same is contemplated in West Virginia Code 58-3-1. So, I don't understand that, and neither does she. We're not attorneys. Maybe there is a legal reason for this.
Yeah.
If there is,
Yeah, I'll just comment, if you don't mind, because this might enlighten others to the extent that it's necessary. I really wouldn't expect you or her to understand what that sentence means. That sentence was actually generated in part out of the litigation with EQT. And the issue was, coming from the Floodplain Appeals Board, does the losing party, which would be the appellant, have a direct appeal to circuit court? And if so, under what statutory authority? Okay? And what Judge Sweetie ruled was that that particular statute, West Virginia Code 5831, that does give the county commission a right to regulate certain things like roads, alleys, avenues, and way. And I haven't used the exact words, but if you read it, you would believe that all those things are roads to travel. I mean, I think that's a reasonable interpretation of that. But a way also could be a floodway. I know that Ms. Huff and Mr. Richardson have brought this forward as a main issue of their contention with respect to adding that language. And I will tell you that when it was brought up in the litigation, I supported the effort to utilize that statutory mechanism to allow the appellant, whether it be the landowner or the oil and gas industry, to go to circuit court, because I thought personally that the circuit court is the appropriate place to litigate the issue, rather than forcing the entity to go to the West Virginia Supreme Court that has a petition process. It's been generally revised here recently, where you may or may not get in. And at the Supreme Court, you don't have a hearing where you bring on evidence and cross-examine witnesses. You're limited to the record below. So when the judge suggested that he didn't have essentially statutory jurisdiction to hear the appeal from the Floodplain Appeals Board, it was suggested by one of the party litigants that this statute would give the circuit court authority. He ultimately ruled that it did not, that there wasn't common law, or statutory definition of way that would give him, the circuit court judge, authority under that statute to hear the appeal on a floodway, because he didn't rule that a floodway was the same way that was utilized in the statute. And I will also add to the comment that one of these code sections, I apologize, it's on my iPad, I could get it, but it takes some time. Under Chapter 7, that exact same language is utilized, giving the county commission authority to regulate a road, alley, way, avenue, and there's some other road descriptions. And I wasn't choosing between EQT or Mrs. Huff. I was just choosing that, number one, in an ordinance such as this, we cannot, the county commission, confer jurisdiction with the circuit court. That can only come from a statutory enactment from the West Virginia legislature. Okay, so this language in and of itself would not give the circuit court venue for this appeal, but it would give at least the court an indication that the county commission is in fact recognizing that they are regulating a way, a floodway, which is what this ordinance does. So that's why it was included. And it may, on this occasion, give the industry an avenue to go to the circuit court, but there may be a ruling that's adverse to a landowner such as Mrs. Huff the next time around, that she could utilize that same statutory language to suggest that I have a right as the appellant to go straight to circuit court, rather than having to file a writ of certiorari or some writ of mandamus or prohibition, or go directly to the Supreme Court. So I really didn't think it was going to be a controversial issue, but evidently it is. But that's the background of why that language was added to this current draft, and that is to say that the county commission is in fact regulating a way. It happens to be a floodway. Now, whether the those who enacted that statutory provision years and years ago contemplated using a floodway, we don't know, because we don't have legislative history in West Virginia. You can't, in some states, I could go back to the legislative history to see what those enactors meant by way, okay? But we don't have that history, so we don't know whether they contemplated at the time of enactment the regulation of a floodway under the word way. We just don't know, and there's no case law in West Virginia that defines way in such a way that would expand it to floodway. So that's why I think Judge Sweeney ruled that word way, that there was no statutory or legal basis to utilize way as an avenue to take direct appeal to circuit court. Mr. McMahon should have the next turn on this, because I know we've discussed this, and he has an opinion with respect to how a party could go to circuit court without the necessity of utilizing this statute.
Okay. With respect to Mr. Tennant, I disagree that this statute is the appropriate statute to use, and Judge Sweeney agreed with me in the order. Here's the question. If there's a hearing in front of you folks, and somebody wants to appeal to circuit court, I think it's very clear that if you use this, if that statute was the relevant statute, that there would be an appeal to circuit court. The appeal to circuit court could also happen through something called a writ of certiorari. I hate to use Latin, but that's what it says in the code. And the distinction is, if one of these people has a hearing against, I'll make you bad guys already, EQT, in front of you folks, and they don't like the result, one of these folks doesn't like the result, and they want to appeal to circuit court, if you leave that language in, then the judge just looks at the record that was made before you. And they probably didn't have a lawyer before you. And they may not have had all the experts and all the testimony and all the pictures they'd want to get in. So if you leave that section in, then when they're in circuit court, they're stuck with what they did in front of you. I think that you should either take it out and leave it for future debate, or say that the appeal is by writ of certiorari. Again, encouraging the circuit court to rule that way. And in that case, if there's an appeal by one of these services, or EQT, either way, then the judge can look at things again. The new evidence could be brought before the judge to help the judge come to a decision. I would urge, on behalf of surface owners, who are usually going to be not do as well in front of you in terms of being prepared and knowing what evidence to present and how to present it, that we say that the appeal would be by certiorari, which would mean the case would be decided anew in front of the circuit judge. Yeah,
the only thing I'll add, just for debate, is in the context of the Board of Equalization and Review, which the County Commission sits as for purposes of tax assessment and appraisal and assessment. You sit as the Board of Equalization and Review, and the evidence taken in front of you is the only evidence. The parties that appeal to circuit court are restricted by what evidence is taken in front of you. So when they go to circuit court, the record of what was presented in front of you as the Board of Equalization and Review is the only record that the circuit court judge looks at to rule upon the legal issues between the assessor and the landowner. So there is some precedent in another part of your job where the record is totally encapsulated in the hearing that's in front of you, rather than having new litigation where new evidence and new witnesses and new documents can come forward at the circuit court level. And I leave it at that.
As another lawyer in the room, I might as well say my 2 cents. With respect to Mr. McMahon, there is a question, and it's not clear whether you could, either a landowner or EQT, for example, could file a writ of certiorari in a circuit court level. I don't know if that's absolutely clear as Mr. McMahon states it. Maybe it is. I'm not sure. However, this provision, I'll take credit for the comment, was one of our initial comments. Obviously, we argued that in full disclosure about what happened in the underlying matter. Judge Sweeney originally said no for no apparent reason. And then he said, we thought he was going to say yes at one hearing. At another hearing, he said no. So maybe if we ask him next time with different support, it may be different. All this statute, all this code does, that sentence, Kevin, is explains and defines what they're regulating. It doesn't do anything with FEMA. As far as I'm concerned, that sentence could be somewhere else in the ordinance if the location of it is a concern for FEMA. But what it does is, because there is a question with respect to Mr. McMahon's position, there is no question that if you are regulating a way, there is an appeal to circuit court. And we can talk about the pros and cons of standards of review and things like that. Quite frankly, this body doesn't have the authority to talk about what standards of review are appropriate. They can define what they're regulating. They can say what they're doing, things like that. The standards of review are based upon the courts or the legislature, and it's not your decision. But the inclusion of this sentence makes it clear that anyone on an adverse decision would have a right to appeal. And that's all that it is. It's not...
It makes it clear that the county commission thinks that. Doesn't make it clear because the circuit judge ruled it.
Correct, that's correct.
But we need to make it clear. The way it reads is
Well,
not clear.
then I would submit to you this, and I'm sure Wapanga, Mr. Tennant, my client, Mr. McMahon, that to be absolutely 100% sure, clear, there's no question ever, that's a decision that's got to be made in Charleston.
The legislature.
At the legislature. But this is the best way that this commission can attempt to do it by defining what they're doing. I agree with you. I think there are a lot of things that are in this ordinance, proposed ordinance, that would be better left decided by the legislature in Charleston. That way it is uniform across the state. And this is one of them. I think there's 6 or 7 appeal rights in that 58.3.1 or 1.3 or whatever it is. They could add floodplains, the ordinances to it.
No, or they could do they could probably do a statute that would be better than either certiorari or 58.3.
That's probably a fair comment, sure.
So we ought to
Take it out.
Bob, let's get out of the legislature next year.
But taking it out happens this, hypothetically. Let's say my client applies for a floodplain permit and Mrs. Huff doesn't like it because they may agree with me this time. Or maybe maybe one of your other landowners. Or you the one that said you had an EQT, maybe we do something there. Somebody, I don't know, maybe back there. And you don't like it. This is not just a right for EQT. We could have filed a brief in the Supreme Court. Lord knows we filed plenty of briefs in the circuit court. It wouldn't have been anything to change the title of it. So this helps everyone.
Mr. Hastings, I sat through that discussion and listened to Judge Sweeney's ruling. One of the things that I walked away with was the fact that if you have a roadway, an alley, and all those stationary man-made paths that people travel on, those act a lot differently than a floodway. A floodway is, I might not be using the right terms in the legalese, but a floodway is a living, changing thing. So you might have a 100-year flood situation where the water's going to move one way, in another situation it's going to move another way, or it's going to do more damage in some stuff and less damage in other situations. Reading this, to me, I seriously feel that if Sweeney ruled how Sweeney ruled, he seemed like he put a lot of thought into it. And to me, we're dealing with the floodplain ordinance. And way, the definition of way,
I know what Judge Sweeney ruled, and
I'm sure you do.
And I think you've interpreted what he said correctly. What I'm suggesting with this particular comment is that this is a way, pun intended, no pun intended, for the county commission to attempt to define what they're doing to come within that jurisdiction. So the next time the judge can say, well, it looks like this is what the county commission intended. The judges have to look at what the enacting bodies, whether it be the legislature, or the county commission, or city council, intended when they enacted the ordinance to see how they're going to apply that law. So that was my suggestion. And it's up to the county commission to take it or not. The big complaint I have, the concern, which I find very peculiar in this scenario, is the major complaint by the Huffs in the underlying matter was there was due process issues. No notice and opportunity to be heard. I can't stand here and disagree with her on that initial process. That was the initial complaint. She didn't have notice of the initial application. She didn't have a right to be heard. Those things. That was a primary argument. It may not be your own. You have your own case. I'm not suggesting that. But that was a primary concern, due process. This is a due process addition to the ordinance. And I would think that Mr. McMahon would at least agree to this. There needs to be some provision for an appeal. And we can debate what that is.
I think there already is a provision appeal in the written certiorari statute, and I think this should come out. And
Yeah.
I appreciate you hearing the argument on this. You got 6 more to do.
Sure.
Yeah, and just so, the reason I started that was I wanted Kevin to hear it because I need to understand whether FEMA's saying, if this is in, we're out of compliance. I mean, are they saying that, or are they just saying they don't understand why it's there?
They weren't worded better. And if it is state law and it has to do with the floodplain ordinance, this is their word, then it's okay to be in there, but it needs to be worded differently where somebody can understand the way it reads. It's just, the way it reads, I don't think anybody in here that's not an attorney would understand it. And that's part of why you all started doing this ordinance.
Well, yeah,
Word it differently, put it under the appeal section.
yeah, we could attempt to do that. Obviously, the way it was worded didn't sneak by anyone, from that respect.
If anybody was at the hearing, they knew what we were talking about, right?
But we could change the be more specific with the language.
Try to word it, put it under section 8.1 in the appeal section, and let's take a look at it even. As long as it refers to a state law and has something to do with floodplain management, I don't see a problem. Okay, let's go ahead.
Can I just clarify this?
Yes.
Because, I agree with Mr. Sneed. Our objective here is to make this ordinance as concise as possible to avoid, and I'm sorry attorneys, I'm not trying to put you out of a job, but to avoid legal hassles where the county gets sued, landowners get sued, landowners sue EQT and other companies, or they sue the commission. That's the goal, I think, for citizens and the commission working together who we elected to help us, as far as protect us. Now, that being said...
But in this case, all the lawyers agree, only the legislature can undo the ambiguity.
No, that's not true.
Yes.
Because if it's an ordinance, and like Mr. Sneed says, that he has an issue with, what the heck do they mean by way? It's a floodplain ordinance. And leaving that loophole by just calling it a way means they can open it up for unnecessary litigation. If they put floodway, that is cut and dried, and we wouldn't be here having this argument.
But it's not
So
in
either
the
leave
code.
it in as floodway or take it out altogether. And then, is that okay, Mr. Hastings, if we do that? Do you have a problem with calling it a floodway instead of a way?
I think that is a legal distinction based upon language of statute, and I agree with Mr. Tennant that he should craft additional language.
We should be concise.
If
what kind of way you mean?
I don't disagree that we can't expand the definition of it or explain it, but if it's the county commission's position that they want to have this type of language to make it appealable, I would submit that Mr. Tennant could come up with some language, and maybe Mr. McMahon and I can work with him on that, submit it to Kevin Sneed, and see if it's okay. I think that's the way this process should go.
It's a floodplain ordinance, so we would call it.
I have
Just understand, ma'am, that the reason that the word is in there the way it's in there is that's the way it is in the statute. It's not like we made that language. That language
Is the
was
statute itself the floodplain ordinance for the county?
taken from the statute. No, the statute is statute that defines what authority the county commissions have.
Right, but if their statute says specifically, or their ordinance says specifically.
Yeah, or excuse
what's
me,
the issue?
the appellate jurisdiction of the circuit court.
But if it says floodway, then they would have to,
Well, the same language though is in the
Yeah.
county commission authorities section 2 in chapter
I
7.
think we all have an understanding of that issue, don't we?
and that's just like I made a reference before, appointment is with the definition. What is the definition of is? Remember that from a few years ago? We don't want to complicate, we want to be concise, so that a lot of things get resolved before they even have to go to lawyers.
I'm sorry, I don't understand. I thought a way comes under the jurisdiction of the circuit court.
It does.
It
So
does.
if we declare a floodway is a way,
Yeah, I mean,
then
if you-
we're saying the county commission and the whole county commission appeals board means nothing. We
no.
have to go straight to the
It
circuit
means after
Not
the county
necessarily
appeals board. It means after the county commission of floodplain appeals board. Let's say I apply for a permit.
Well, that's what we did.
Now, I know. The impact of that, let's assume it left in and it stayed as such. The impact would be this. Either one of us apply for a floodplain permit. It goes to the floodplain, and Mr. Wellings approves it or denies it. And then the floodplain appeals board will make a ruling. It will be their right to appeal that ruling. It doesn't mean you skip the appeals board or skip the floodplain administrator. It means after the floodplain administrator and after the Doddridge County Floodplain Appeals Board, it then could go to the circuit court before going straight to the West Virginia Supreme Court. That's all it is.
Don't we have that right anyway?
There's a question. Judge Sweeney said no.
Judge Sweeney said he didn't have jurisdiction because the floodway was not a way.
Judge
He
Sweeney
doesn't have
specifically said
jurisdiction under that statute. We say he had jurisdiction under certiorari.
he said he had no jurisdiction here, any appeal of the case. I mean, in the
He
first
didn't bring
hearing.
a certiorari action, so he couldn't say it was good or bad.
Yeah.
If what we're trying to do is come up with the best document ever, it seems like the word insertio, going to the legislature is too long. I think that, maybe eventually to clear this up. But if that's going to give people the right to have more documentation, some witnesses, more information so we can make a better case regardless of whose side it is, then that is the best we can come up with, the insertio. That would not be a problem then with the judge either. So to me, it seems rather clear that if we change that language that's confusing, we're leaving the intent of it there, we're just coming up with a better method of doing it.
I believe that FEMA is going to be okay with it, whatever the attorney comes up and Doddridge County decides on this, Doddridge County's attorney. They just want better explanation of what that law is. And I can probably send them that code, that's not a problem. But then they're going to look at it as, what is he talking about, floodway? Right of way.
That's right.
You just
Insertio is better.
And that way, it might be best to look at that one. I don't know. So like I said before, I'm not an attorney, so we'll work on that. We'll decide, we'll look at both of them. I don't know about the one he's talking about, but I'll be glad to review it as much as possible. And if I have to, I'll send it to the State Attorney General's office and we'll get their input.
You got a comment, Tammy?
I'm looking at the same thing she's looking at. The way it's written, we're going to be limited to only, in other words, whenever we walk into the appeals board, we're going to have engineering studies, have everything prepared. So if we go to the circuit court, that we can take all that stuff with us. Now, I know whenever I walk into a hearing before an appeals board, I walk in without an attorney, without everything documented, and it seems like that's going to take our right away, where the writ would give us full rights to do what we need to do in the court.
Let's do this. I'll take this one, and I want you to send me that information. Both of you all send it to me. I got to contact the Attorney General's office. I can send her an email. I can go up and talk to her. I'll get the right response. The Attorney General's, that's what they do.
Yeah.
And I'll take care. I'll look into that, and I'll recommend to the commission, which I'll let the commission know exactly in writing what the Attorney General said on that one. Because that's something I can learn about. So that sound fair? Second. Section 3.1A should include reference to the 1% annual chance flood along with the 100-year event. The 100-year event, you always hear the 100-year flood, the 100-year floodplain. FEMA has gone away from, or venturing away from saying the 100-year flood because everybody said, well, it ain't flooded here in 100 years. Well, it's actually not a 100-year flood anymore. It's actually the 1% annual chance of flooding. That's what they've changed their verbiage to. They've been changing that for years. So that's what they request that we change that in section 3.1. That's a pretty easy one. It's just adding 1% annual flood.
Where again?
Let me go to it here.
3.1A?
Yeah, I believe so. Let me go to it.
And change it.
3.1A.
And where?
Hold on one second.
What page is it on?
Page 14.
Thank you.
There you go. 3.1A. Subject to the, or instead of putting in 100-year flood, before the 100-year flood, put 1% annual chance, 1% annual flood, and then in parentheses put 100-year flood would be fine. They just want 1% annual chance of flooding in there somewhere, instead of just 100-year flood. That's a pretty simple one. I don't see how anybody can argue with that. It's 1% annual chance of flooding. It's like that around the whole United States.
So it should say 1% annual change of flooding.
Annual chance.
What does that mean?
Everything right. They use it in a lot of training. I know that because when they go up for training for floodplain management, you a 30-year mortgage, for some reason they come up with 26% of the chance of flooding in a 30-year mortgage. You go get fire insurance. Do you know what the chances of you having a fire is on your 30-year mortgage? It's 1%. If you get a 30-year mortgage and you live in a floodplain, your chances of flooding are 26%. That's why they're changing it to the percentages instead of the 100-year flood, because everybody thinks, well, every 100 years it's going to flood. And that's, the old way of saying it, but now the right, correct terminology is 1% annual change.
Yeah, that is actually utilized in this ordinance in some other locations.
Yeah, it is. It's, I didn't think that'd be, that's just one thing that needed to be changed, and it's something simple.
Is it the same boundaries though as the 100-year flood?
Yeah, yes, absolutely.
Exact same thing, just explain
Just
it.
different
It's
wording.
like, it's based on a statistical model of saying you have 1% chance of getting a flood each year over the next 100 years. And then because of the statistical variations, that's what he said over a standard 30-year mortgage, it's actually a 26% chance you will be flooded in that area, or 1 in 4. And it's much higher for a fire. In other words, it's going to flood a lot more often than
Catch fire.
3.1.
Just for purposes, I take it, is there any objection to that change from anyone that's present? Okay, so that's one we can move forward on.
The next one, if you'd all go to page 6 of your ordinance, the very top page, page 6, it is the definition of development. This is cut and dry for FEMA's eyes. The definition here is not going to work. It's not compliant. They won't accept it.
I'm sorry, definition of what?
Of development.
Oh,
It's actually the 11th definition, but it's on page 6 at the very top. They cut off development, and that's, I'm showing page 6. It's the development definition. I got the code 44 regulations here, and it actually specifies the definition of development. They are very strict on these definitions. Definition of development says this, and I'll stop. What they did is they added the last 4 lines basically on it. Any man-made change to improved or unimproved real estate, including but not limited to buildings or other structure, mining, dredging, filling, grading, paving, excavation or drilling operations, oil, gas well sites, pads, pits, retention ponds, or storage or equipment materials, period. The rest of that does not belong. I got it in Code 44, Code of Federal Regulations right there. If there's any question about it, I'll be glad to show it to you. Anything added to there is not a part of the development definition.
Yeah, let me just state where that came from and explain why. Pardon me?
Tell everybody what the first one's being deleted. Can he read what's being deleted?
Yeah.
are you just deleting the last sentence?
Yeah, what he's suggesting should be deleted according to FEMA is these words. Development does not include excavation for installing underground utilities or infrastructure when the post-construction grade is the same as the pre-construction grade. Okay? This was a suggestion made by the oil and gas industry, and the issue is this. They're putting pipelines everywhere. Yep. And these pipelines are going to carry the oil and gas, wet or dry, from the drill site to this main line that's either going to go to Canada, going to go to New Orleans or Houston, or going somewhere else, maybe to a cracker plant in West Virginia. The issue is whether they have to, for purposes of simply digging a hole to put that line in, where they're going to essentially put that dirt back in and surface that grade as it was pre-construction, whether they'd have to go through the floodplain permitting process to do that work specifically. That is laying the line, so to speak. And since it's not changing the grade of the land, it's not adding fill to the land, it's simply taking dirt out, putting a line in, putting dirt back on, that it seemed reasonable to me that we wouldn't have to force the oil and gas industry to get a floodplain permit to do that. Now, the only concern I had, though, was whether, while they have the dirt out of the ground, that a flood hits, then you have all that dirt going down the river. But that's why it was added at the suggestion. And to be honest with you, I thought that was reasonable, that they wouldn't have to go through all this floodplain permit process to simply do that. But if FEMA says that we can't define it that way,
That was a definite cutoff. She said that absolutely cannot change the definition. If the definitions are from the FEMA 44 CFR, which I have right here, you cannot deviate from them.
To echo what Don said, and I appreciate the definition, I still think, on behalf of my client, that there does need to be something. I mean, if you want to take the observer zone, it would also apply for digging a sewer line at your house. or putting in a septic tank. I mean, that would all apply, you're not doing anything digging a hole.
No, because you can't put a septic tank in a floodplain.
Well, there are other issues with burying propane. There are various issues, but the more practical problem with it is, and if we can maybe just get an exemption for that, as opposed to take it out of the definition and put an exemption into it. Because if we do a pipeline, no matter what, we could be over 150 different tracts of property that things are already regulated. We have notice, whatever it is we have to do. But for the county commission to say that we then have to go get a floodplain permit and provide notice to every landowner, everybody beside the property, because there's not going to be any effect on the base flood elevation at all for that. You're digging a hole, even if you just laid a pipeline on top of the property.
I agree. I agree.
If
you put the ground elevation back the way it was, that's fine. But what if during the digging and you have all that pipe out there, and a flood comes and all that pipe gets washed down the stream and hits, some barns or people's houses and hurts somebody? I mean, and there's nobody there to say, hey, I gave a permit to that. You got to permit it. It's development. Anytime you're digging, dredging, it's all there.
Okay, and I understand that, but again, if we're going to go down that road and not try to craft something in there, there really needs to be a consideration for permitting fees on that issue and what kind of notice. Could it be a short thing if it's a pipeline? Because it's going to get the process is burdensome. You're not going to be able to send the sheriff out and serve 600 residents of Dodge County because the pipeline is going across the mountainside. That's not practical. So there does need to be some provision. And I respect FEMA. Look, FEMA says no.
I understand what you're saying too.
But there has to be something.
I think there ought to be time limits on it, and I think it's up to the county to give you a waiver on the fee. It's totally up to them, But
and I'm not sitting there saying that we shouldn't be feed for development we're doing and things like that. I just think that it's going to create a practical impossibility that this county commission may not have authority to regulate.
Go ahead, Anya. You got your hand. Wait a minute, yeah.
Mr. Foster, there's someone behind.
There's a lady behind you who's been waiting.
I didn't see you.
Okay.
This is a perfect example. On Arlen's Creek, you know how we have that big meadow and there's all kinds of pipelines in there. EQT came in and they laid a pipeline down. They had the place opened. Now, I could put some underground wire and I'm not going to flood half the, wipe out Ralph